right. Good evening. The November 9th, 2022 meeting of, why am I echoing? I don't have Teams on or anything. Hello?
I'm getting it too, echo.
Madam Chair, this is Stephen. I'm just wanted to let you know I don't hear an echo online, so it seems to just be occurring in the room.
Hello?
Hello? Seems better.
Testing.
Try this again. Sounds
Testing.
Okay, it seems to have gone away.
It's
A little. Yeah.
Okay, it's good now, yeah.
Like, am I hearing myself? Okay, let's start this again. Good evening. The November 9th, 2022 meeting of the Arlington County Board of Zoning Appeals is now in session. Welcome to this meeting of the Arlington County Board of Zoning Appeals, which is known as the BZA. I'm Lindsay Arthurs, chair of the board. The board is made up of 5 citizens appointed by the Circuit Court. In addition to myself, we have Vice Chair Judy Freshman and board members Inta Malice, Portia Clark, and Richard Kaplan. Also present are the professional staff, including Blake Bowen, Board of Zoning Appeals Coordinator Megan Ryan, BZA Associate Planner Stephen Rissy. I think I'm missing someone's title there. Yeah, potentially.
Stephen Rissy is the Z-Prim supervisor.
Maybe it was the way I was reading it. It wasn't flowing right. Sorry, guys. This is our 3rd in-person and virtual hybrid meeting. I think we've figured out most of the kinks, but please bear with us if there's some technology issues. We're still all learning how to do this. Before we call our first case, I will share with you some general information about the Board of Zoning Appeals and then some ground rules on how we will conduct our hybrid meetings. The board's powers are prescribed in the Code of Virginia and are set out in further detail in the county's zoning ordinance adopted by the county board. The Board of Zoning Appeals does not have the power to rezone property or to amend regulations set forth in the ordinance. That authority rests solely with the county board. This board does have the authority to do 3 things. We can approve use permits to allow modifications of placement requirements on structures on 1 and 2 family lots where there is no option in the zoning ordinance to allow such modifications. We can grant variances from the specific requirements of the zoning ordinance, and we can decide appeals of the decisions of the zoning administrator. Now here are some specific instructions for this evening's hybrid meeting. First of all, please silence your cell phones and mute yourself on Teams. Applicants, if you're attending in person, when your case is called, please move to the podium in the front of the room and identify yourself. Please be sure to speak into the microphone for the benefit of those on Teams. Speakers, please move to the podium in the front of the room when called upon, and please be sure to speak into the microphone for the benefit of those on Teams. Applicants and speakers, note that the podium is adjustable. Tonight's meeting is also available to stream via the county website on a Microsoft Teams link. If board members, presenters, or speakers are attending via Teams, if you happen to lose connectivity during tonight's meeting, please reconnect to us by phone. If you're attending or viewing via the Teams link, please keep your phones and devices muted until you are called upon. Please turn off sound to any devices around you to minimize interference. For those of you joining on Teams, please turn off your video until you are called upon to speak. When called upon to speak, please turn on your camera and unmute yourself by clicking on the microphone icon and the camera icon that are located on the meeting command bar. The moderator does not have the ability to unmute you. The meeting chat is active for presenters and board members who need technical assistance only. The meeting chat should not be used for discussion, public comment, questions about agenda items, or requests for more information. All public comments must be shared verbally for the record during the assigned public testimony period. Applicants and public speakers, you will be called upon by the county staff at an assigned time. We request that all speakers pre-register for tonight's meeting. If you did not pre-register but wish to speak, speaker slips are in the box next to the clerk to the left of the board. You have it, right? Yeah. If you're attending via Teams and wish to speak but did not pre-register, please try to, how do we want to chat? I guess put something in the chat.
Sure.
Yeah, that'll work. We will do our best to accommodate any additional speakers if the time permits. Public comment will take place only in the allotted time frames. During public comment, a speaking timer will be displayed on the screen and on the podium. You will be muted when your time has concluded. Please be respectful of the time allotted. Lastly, this is a public forum. Tonight's meeting will be recorded and posted on the county website. All information associated with today's meeting, whether written or spoken, is subject to the Freedom of Information Act requirements. After your case of interest is heard, you are welcome to stay for the balance of the session, but we will not hold it against you if you want to continue with your evening. For tonight's meeting procedures, the staff reports for each case on tonight's agenda can be found on the BZA website. A link to the agenda can be found in the chat session as well as on QR codes on the front table to link to the electronic reports for review on your phone. A limited number of paper, do we have paper copies?
We have 1 or 2 staff copies.
A limited number of paper copies for the staff reports are available. If you have not seen your report for your case, you may wish to review it before your item is called. Supplemental materials have been turned in after the staff reports were prepared for a good portion of tonight's cases, I believe. There's a separate link in the agenda site to link to that material. The order of our meetings is as follows. First, the cases will be called and board members will ask any questions they have of the zoning staff. Next, applicants or their representatives will be given an opportunity to make comments to support their application. Then, if there are any speakers for an item, they will be called upon. After we hear from the speakers for or against the proposal, the board may permit the applicant a brief opportunity to clarify any points. The board may also ask questions of any speakers, but we do not permit and will not condone any cross-examination or direct questioning by others. We have deemed the following time limits for applicants and speakers to be sufficient. 5 minutes for applicants for use permits and variances, 3 minutes for speakers representing organizations, and 2 minutes for those speaking as individuals. After the board has gathered all the information we need and has discussed the case, we will decide the matter by voting on a on a motion duly made and seconded. A majority is needed to approve any motion. Any appeal from the decision of this board must be made to the circuit court in accordance with state law. This concludes the introductory remarks. Mr. Bowen or Ms. Ryan, will you please call the first item?
Yes, Ms. Arthurs. The first 2 items are withdrawal requests that do not require specific action on the part of the BZA, but we would like to read them into the record as being withdrawn.
Sounds great.
The first case is case number V-11767-22-VA-1. This is a carryover item, a variance request by William B. Lawson Jr. on behalf of Bradley and Eleanor Patute, the owners, to permit a main building footprint of 4,574 square feet instead of 3,920 square feet as required for a one-family dwelling with a qualifying front porch in the R10 zoning district, regarding a new one-family dwelling with front porch, attached garage, and a rear deck in the R10 zoning district on the premises known as 4620 36th Street North in the Old Glebe Civic Association. The second case also requesting withdrawal is case number V-11770-22-UP-1. This is also a carryover item, a use permit request by Ken Reed on behalf of Mariam Ansari, the owner, to permit a street setback of 20.2 feet to the main building, 18.2 feet to the eave instead of 25 feet to the main dwelling, 21 feet to the eave as required, a street setback of 16.4 feet to the stoop instead of 21 feet as required, and a street setback of 16.6 feet to the window well instead of 21 feet as required, all from 19th Street North regarding construction of a new one-family dwelling in the R6 zoning district on the premises known as 4730 19th Street North in the John M. Langston Civic Association. Again, these items do not require any action on behalf of the BZA and are being withdrawn. Hearing that, I will move on to the next three cases. I believe these are items that the BZA is inclined to grant a group motion of approval towards. Is that correct, Madam Chair?
Yes.
Okay, thank you. The first three items that are in this group motion then are case number V-11783-22-UP-2, a carryover item. This is a use permit request by Elaine and Terry Eby, the owners, to permit a left side setback of 4 feet to the proposed side addition, 3.5 feet to the eave, instead of 14.6 feet to the proposed side addition, 10.6 feet to the eave as required, and to permit an aggregate side setback of 7.4 feet instead of 18 feet as required regarding a new side addition to an existing one-family dwelling in the R6 zoning district on the premises known as 3817 13th Street South in the Douglas Park Civic Association. The next case in the group motion is case number V-11793-22-UP-1, a use permit request by Jeremy and Christina Landis, the owners, to permit a street setback of 19.7 feet to the porch, 18.6 feet to the porch eave, instead of 21 feet to the porch, 19.5 feet to the porch eave, as required from the North Irving Street right-of-way regarding after-the-fact approval for a front porch on an existing one-family dwelling in the R6 zoning district on the premises known as 207 North Irving Street in the Lion Park Civic Association. The third and final case in the group motion is case number V-11794-22-UP-1. This is a use permit request by Sukaina Lamari and Mule Idris B. Marani, the owners, to permit a left side setback of 9.5 feet to the rear addition instead of 10 feet as required, to permit a right side setback of 9.5 feet to the second story addition over the non-conforming garage instead of 10 feet as required, and to permit a street setback of 20.9 feet to the eave instead of 21 feet as required from the North Littleton Street right-of-way regarding a new rear and second story addition to an existing one-family dwelling in the R6 zoning district on the premises known as 518 North Littleton Street in the Boulevard Manor Civic Association. The staff recommendation in all these cases is to approve the use permits subject to the conditions listed.
Madam Chair,
Yes.
I have a question.
Yes.
Was 117091, which was our number 7 case, was that considered for a group motion?
I don't think it was. Does anybody recall?
I just,
I have just items number 3, 9, and 10.
3, 9, and 10, and not number 7.
Yeah,
Okay, then I have nothing to disclose.
you don't. Okay. All right. Would anybody like to make a motion?
I would move that the 3 cases read for consent be approved.
Second. The motion has been made by Ms. Clark, seconded by Ms. Freshman. Is there any further discussion? I will call the roll. Ms. Freshman? Aye. Ms. Malice?
Aye.
Ms. Clark?
Aye.
Mr. Kaplan?
Aye.
Chair votes aye. Motion to approve the applications pass 5-0. That concludes those matters. Would one of you guys like to call the next case, please?
Yes, and for the record, Ms. Arthurs, I will be calling all the cases except the last one, if that takes some of the stress strain off you. The next case on our agenda is case number V-11789-22-V8S1. This is a variance request by Roger Moore on behalf of Roger Bohr on behalf of Li Ming, the owner, to create a lot that does not meet the required lot width or the required lot area for the R5 zoning district regarding the creation of a new lot in the R5 zoning district on a premises known as 822 18th Street South in the Aurora Highlands Civic Association. Staff recommends that the board adopt the attached proposed resolution denying the variance request. An alternative resolution has also been provided should the BZA see fit to approve the variance request as advertised.
Does anybody have any questions for the county staff?
I do. So if this were to be approved, would it be required that the structures are built according to the plans submitted?
The variance request is simply to create the lots themselves that do not meet the requirements of the zoning ordinance. We do not have specific plans for a building permit yet, so I wouldn't say that they would be tied to those specific houses. And if they did not meet zoning ordinance requirements, the applicant would be required to come back to the BZA regardless for a BZA use permit.
Because there are plans submitted with this, and I just wondered if they meant anything to us at this time.
I believe the way to look at this is that the BZA at this point is just making a decision on the lot sizes themselves. We do have some, let me take a look at the specific drawings we do have, just so I'm not speaking out of turn. Give me just a moment. So, Ms. Malice, in terms of the alternative resolution for approval as advertised, we do not have a condition that speaks to specific drawing sets. We just, the only condition we have is one reading. The applicants will obtain final approval and record the proposed re-subdivision of the subject property by November 9th, 2023, or this variance will be null and void. I don't think there's anything in the approval that would specifically tie the applicant to these specific drawings, although I do believe that these drawings currently represent the applicant's intent for the property if the variance is granted. And beyond that, if they didn't meet the zoning ordinance criteria, as mentioned before, they would be required to come back for a BZA use permit.
Okay, so we can ignore the plans. Okay, thank you.
Mhm.
Anyone else?
Ms. Arthurs,
Yes.
I just wanted to confirm that, like you said, if this was approved as a substandard lot, they would have to come back for approval of the plans, the housing plan. Is that what you said?
Not necessarily. The BZA approval would not be, a building permit approval. So they would have to submit a follow-up, at least a building permit to build the project, and possibly other permits that would be necessitated by the county. But yeah, they would not necessarily be tied to the particular plans that are in the packet at the moment.
It strikes me as challenging that if you're creating a substandard lot, which personally I don't support, but if that were the case, that it would be difficult to come up with a plan that would be worth building that met required setbacks when you're talking all the setbacks on all four sides when you're still talking about substandard lot.
Oops, I agree with Ms. Freshman. I don't think they can build on a substandard lot without
Right,
coming to
where
BZA.
Where would the permit office go to find the regulations for it? I don't think they exist, right?
I mean, even if they built the skinniest thing possible, isn't a non-conforming lot required to come to BZA?
Yeah, and that's the source of this variance, is that they would be getting approval to build on a substandard lot.
Without
Well-
seeing the plans?
We don't know what they're going to build.
I know that the applicant, who may be able to shed some light on this issue, has worked hard to avoid the potential need for a BZA use permit. So I think they are, relatively certain that these are the plans they would build, but I don't think they would be absolutely tied to them based on the condition language that we have in the staff report. The BZA is always welcome to impose an additional condition tying them to these particular plans if they see fit.
They would need a variance to build on a substandard lot.
They would need this variance.
Because even though it's substandard, we are giving them permission
Go
to
subdivide and then come
make
back.
it buildable.
Well, they can't subdivide without us. It's the same thing that happened. We saw that case. Did we see that case
Last month or the month before?
Yeah, recently. They needed our permission to subdivide
What comes first, the chicken or the egg?
to allow. Exactly, right.
Right.
But then we had plans to see what they were going to build.
I can't remember.
So this variance would be both for the ability to subdivide and the ability to build plans which I guess the applicant can address whether he's tying himself or herself to the plans in this application or not.
Because what's before us is simply to create a lot,
Right.
not to build.
Although there are plans. Right. I'm with you.
I think we should hear from the
Yeah,
applicant.
I'm
Maybe.
confused, but I'm with you.
I'll be happy to chime in after the applicant speaks. If
Okay,
needed.
that sounds great. Mr. Boer, are you ready to speak?
Yes, absolutely. So
Okay.
what we have here is, just to start off with the question at hand, we are absolutely tied to those plans and that design that we have presented. And we have no problem if you want to make us hold our feet to the fire for those plans. We are perfectly happy. That's what our client, the owner, wants to build, and we have no problem with building that exactly as it's shown. We've already made some modifications to make sure that we didn't have to require any setback variances or anything they're doing with coverage or anything like that for these lots. It's simply what we have here is a situation where we have 3.5 lots under one RPC number. The 3 lots themselves, we could build on them individually, although we would not fit anything on them, or we could build those 3 lots as one thing. It's only when we take in the whole lot number 28 and adding part of lot 29 and trying to build on that is where we get to the point where we're not allowed to build on 28 and 29 and part 29, but we're allowed to build on 28 itself. And also we've been told with our letter that we could actually build potentially on 26, 27, and 28 if you could physically make a house fit. Now we know that's not possible. But also in this, we're not, I know it's technically a subdivision, but we're not creating any new lots. We're taking 3.5 lots and consolidating them down into 2 is what we're trying to do. And it's just a weird quirk of how it's all looked at, in the ordinances as to why we need this variance for our building.
So, Mr. Bowen, have you evaluated the plans? Have plans gone through plan reviews to determine whether a use permit is not required?
Yeah, based on the current plans that have been submitted, a use permit would not be required. And this was a little bit of a tricky issue leading up to it because we'd be creating, if a use permit had been required, at least one of the properties that was being created would not have an address assigned to it because it doesn't exist yet. So we worked with Roger to kind of sidestep that issue, and we have the variance request at the moment, and we did take the plans through our plan review group as well as a detailed look from Meg and myself. Yes.
Okay.
And the plan reviewers and Meg and I we all agree that a use permit is not currently required based on what is shown on the plans that have been submitted.
Does anybody else have any questions?
So I guess a comment and an applicant can respond. Your alternative is that you could build a single family home on the lot as it exists today.
Yes, correct. We could fill one single family home on it with the current one RPC number, one address on the 3.5 lots. Yes.
And that doesn't seem like a good option to you.
It's not the option that the owner wants. I mean, he could certainly fall back on that, but he got into this looking at the property, and we looked at the property as a potential for 2 units, and that's sort of what they would like on their investment. I know you can't take money into account, but that's the reason for it.
And Mr. Bowen, staff is recommending denial because it doesn't meet any of the standards for hardship.
Yeah, we didn't believe it met the standards for hardships, and also the zoning ordinance stipulates minimum lot width requirements and minimum lot area requirements for the R5 zoning district, and this lot simply isn't big enough to do that by right.
Question?
Yes.
Was there any effort made on the part of the applicant to reach out to any of the neighbors?
There was only minimal, there was only the sort of the minimum notice requirement. We did not meet with all the neighbors out there or have anything outside of what was generally just required to publicize what's going on.
Well, actually, on this BZA, it is required.
Okay. We had not had any other formal comments with the neighbors other than, just our preliminary stuff when we met neighbors out there. That's it.
In my view, it would at least be a deferral for that, but I wouldn't recommend a deferral if the board does not wish to approve it, even if we had neighbor comments.
Anybody else have any comments? I am, for my own personal, I'm kind of stuck. I feel like this is something that's being discussed all over the county that I just don't think we have the authority to do anything for. That it's not like, and I think the hardship is that it's not where we've talked about in the past how the county board might cause a hardship by ignoring certain things. They're clearly not doing that now. It's very much a hot topic. And I feel like us making some kind of decision on it might be jumping the gun.
I agree, and I think if the neighbors were aware of it, they would consider it subterfuge.
I mean, looking at all the lots around it and the, massive apartment building across the street, I don't know that they would, I don't know, maybe, possibly. But I mean, it's very mixed use around here, so I don't know that may come into play. The adjacent lot has a very interesting house on it. It's just incredible that they even built a house on it. But that's the nature of these lots that were made very small for a very specific, very terrible reason. Yeah, it's tough. Yes.
I'm prepared to make a motion.
Okay.
In view of the fact that I think that the hardship test has not been made, I move the Board of Zoning Appeals adopt the proposed resolution denying variance V-11789-22-VA1.
Second.
Motion has been made by Ms. Freshman, seconded by Ms. Malice. Is there any further discussion?
Let me just make a quick comment.
Yeah.
Because, I'm having trouble with both the hardship test as well as the county board can act in making undersized lots buildable. And I'm not sure that we as a board want to create a new non-conforming lot, right? Those are generally frowned upon, and that will follow this board, forever for any and all changes that could be made. Although they might not need to be, but it would be a non-conforming lot.
Yeah.
So I'm having trouble with those, even putting that last one aside, I'm having trouble with the, meeting the hardship, right? Where this applicant is relying on the actual zoning ordinance for a hardship. Well, you can make that claim under any of the zoning rules, right? I want to go above the 43% on an R6. That's a hardship to me because I should be able to go to 45 because someone else who pre-existed that zoning ordinance was able to do that, right? So where's that line for the hardship? And then again, this is if the county board wanted to address, the ability to build on less than 50-foot wide lots, they could.
And they're talking about all
They're
kinds
talking
of
about
changes.
Right, and something very well may be done in the near term to address exactly this issue.
Or it might not be done at all, but they're at least discussing the option,
sure,
which
right.
is more than they've done
for
a while. Yeah.
Right.
I do appreciate all the work that you've done to try to figure out a way to make this work. Just as one last comment. Anyone else have anything else? I'm going to call the roll then. Ms. Freshman.
Aye.
Ms. Malice.
Aye.
Ms. Clark.
Aye.
Mr. Kaplan.
Aye.
Chair votes aye. The motion to deny the application passes 5-0.
Sorry.
Thank you very much.
Good luck.
Thank you.
All right. Mr. Bowen, can you call the next case, please?
Yes, Ms. Arthurs, the next case the next property concerns both a variance and a use permit. I'll read the variance application first. This is case number V-11790-22-V8S1. This is a variance request by Ian Whittington on behalf of Gloria Whittington, the owner, to permit a new addition that exceeds 50% of the aggregate floor area of the existing building on a lot that does not meet the lot area and lot width requirements for a semi-detached dwelling in the R27 zoning district regarding a new rear addition, front addition, and front porch to an existing semi-detached dwelling in the R27 zoning district on the premises known as 832 South Irving Street, Arlington Heights. Staff recommends that the board adopt the attached proposed resolution approving the variance request with conditions. Please note that we did receive supplemental materials for this case as well.
Can you describe the supplemental materials?
Yes. In this case, the applicant initially submitted for just the use permit and was not aware of the variance application requirements. So several pieces of documentation were submitted as an update to speak to the variance approval criteria. So we have, in addition to what I just described, overall we have 2 emails, a revised statement of justification, an updated owner consent form, and 5 letters of support from neighbors.
Got it. Okay. Anyone have any questions for the staff?
This is a case this is similar to cases that we've heard in the past, as recently as last month. And I was not able to support it because of my view that this is a matter that the county board could take action on and has chosen not to. And even though we have raised it with the county board, I don't think that we can interpret their lack of response as being delinquent in getting back to us, but rather that it's not an issue that they want to tackle at this time. So I want to clarify that. So my position really hasn't changed on this. But I think last time there was this feeling that, well, we should just move ahead because the county board has been derelict in responding to it. But I think they would have responded if they thought this was a matter that needed immediate attention.
It's not lost on me that the words that I said in the last case are kind of contradictory to what I said the last time we went through this, which didn't occur to me until right now. So yeah, I see your point.
I wanted to just clarify that so that, I know we're going to hear more about the case, but that is where I was before and where I still am. And I just didn't want there be any confusion that we were somehow blaming the board for not acting on it when it's their decision on what they think is important. And further, we've had cases where, the board will change things when they hear from the public, not from us, but when they hear from the public that it actually, is hurting constituents, not hurting BZA members, which is a very small subset of who they listen to. And the public has been successful in getting attention and making the case where, the BZA members may not.
I think we've encouraged applicants to reach out to the board in the past. I don't know if they have or not. Mr. Whittington, would you like to, anyone have any other questions?
I'm going to hold my comments for after
Okay.
the applicant.
Can you hear me?
Yeah, pull it a little bit closer though.
Hello?
You can raise the podium up a little bit. There's a note of the thing on the side.
Is that better?
Great.
Well, first, good evening. Thank you for hearing our case. First, I would like to submit a document, a medical showing about a medical issue we've been dealing with recently. My mom takes care of her sister, who is 80 years old. She, at her age, it's already been difficult for her to go upstairs. And recently, we actually for the past week, she's been in the hospital. And going up the second floor is very difficult for her. And we imagine it will continue to be even worse. We currently only have a bathroom on the second floor, and that is also where her bedroom is. And so a big part of the project would be to add a bedroom and a bathroom on the first floor. Eventually, so my mom can age in place, but the immediate need for my aunt to alleviate her having to go upstairs. And I do have a note from the doctor. If
Please
you
do
need it.
not. Your word is good.
Okay.
Just clarification, if a medical claim is being made on a variance, there's a process that staff would have to go through to verify those claims, correct?
The document I have is from Inova, and it's from her doctor describing her current hardship.
We're not in a position to evaluate medical claims, so that's part of the new change to the law that says that certain disabilities can be considered, but they have to be reviewed outside of this meeting, is my understanding. Because we can't evaluate medical claims here among the five of us. We're not in a position to.
That's not the whole reason that you're doing this.
Well, I mean, we've been wanting to add an addition because, as I'm sure you can tell, it is a small property. But my aunt has been living with my mom for the last 2 years, and so it is the immediate need. It's the immediate reason that we do urgently need to have an addition.
I'll defer to you, Blake.
Yeah, the particular subset of the variance criteria relating to disabilities, I believe we've only reviewed once as an actual submittal. So we did run that by the county attorney's office at the time to make sure that the documentation that was submitted was appropriate. In this case, I guess the supplemental material, we have not had the opportunity to pass it by the BZA. I would be inclined to collect the material for the record, but I mean, of course, it's up to the BZA whether or not to what extent you want to review it.
If you're inclined, go for it.
So
I don't need to see it. I trust you.
I would, personally, I am inclined to deny this because this is something that, absent the medical issue, it doesn't meet, in my view, meet the criteria. If there's a medical issue, then it could meet the criteria, but then it has to be reviewed by the county attorney. So I would not, if I was to vote to deny this, it wouldn't be based on any medical issue. It would be based simply on the hardship and the other facts that we have before us.
Madam Chair,
Yes.
could we not defer it then for a month and have it sorted out by the staff and the county attorney?
It would
Because
be,
if that changes your interpretation of variance hardship, I think that's important enough rather than hashing it out here. As we are not experts, and even those of us who may be attorneys are not expert necessarily in that. So that's would be my recommendation.
I would, if that is the basis for your claim, that it's a disability situation, then it needs to be reviewed by the county attorney, and you could come, that would take at least a month or two, and you could come back, and if the county attorney agrees that it meets those criteria, then we would have a standard by which to approve it.
Okay.
Would that be something that you're interested in? It seems like the need is pretty immediate.
It is. Well, is this the only? Would this be the only way that the variance, in your eyes, could be approved?
You don't know what how we're gonna vote. It may or may not be.
Can I ask if staff considered the medical need, even with the statement that was in, that it was for an elderly relative, so they don't have to keep going up and down the stairs, but they just didn't have the medical documentation with it?
We coordinated with Mr. Whittington a bit about it and discussed the requirement to have more or less a doctor's note. And we did not receive it in time to formally and fully review it for the staff report.
I would like to address that. We have been working on that since we were told that would be something that could potentially be asked of us. But we weren't able to get a doctor to be able to send it until today.
Because doctors are doctors.
Yes. And I just would like to add that another reason is also just so my mom can age in place. We have lived here since 1996, and it would be a lot easier for her as well when she gets older to have the option to also have a bedroom and a bathroom on the first floor.
So those are your options. If you wish to claim a disability, we would have to defer this for a couple of months so that it could be reviewed.
Okay.
And Ms. Malice, I would add that it would probably be best to do a 2-month deferral
I
because
said
we're about to
couple of months.
finalize our December agenda. We
Couple
might need more
months,
time.
Yeah. It would be a 2-month deferral, and that's December, January?
It would also give you the opportunity to show your plans to the neighbors to the rear, which we don't have, but who would be impacted because of where you're putting the addition. So typically we want input from everybody, but in this case, it would be more important to the people behind you even than the people across the street from you.
Okay. We did make an attempt, but we were not able to make contact, but we could still attempt to do that again.
Break hiatus would allow time for that as well.
So would you agree to a deferral?
I mean, just to be clear, is that really the best? Would we recommend that as the best course right now?
We can't advise you on the best course. We could just tell you that without it,
It's harder.
We may or may not approve this variance. With that hardship condition, we would be much more likely to approve it because it meets a standard that we have to, that we apply to these cases.
I would like to make a statement. I am in support of the application. One of my first cases on the BZA was denying something similar on this street, and I walked it 2 days later, and there's a gazillion houses on the street that have additions, and it's stuck with me since then. For what that's worth, I'm in support of the application.
I will say that our plans are not anything drastically different from multiple houses in our immediate area. There are several examples nearby where they have gone into the attic, they have added a back addition. And so what we're doing is not new to my street.
It's true. Anybody else? Ms. Freshman.
I think I'm prepared to make a motion for a 2-month deferral for the reasons stated in the discussion and to allow the applicant to meet with neighbors to the rear and also just look at some of the issues raised by staff in the use permit, which they're recommending for denial. Might as well look at that at the same time.
I will also say that we are.
Did you make a motion?
No.
No, not yet.
Well, I will also say that in terms of the alternatives presented for the use permit, we are prepared to accept those alternatives.
We'll need plans.
Okay. Motion?
Go for it.
In the case V-11790-22-VA-1, I move deferral to the January BZA 2023 BZA meeting.
We haven't set a date for it yet.
Yeah.
Okay.
So
I'll second.
Date to be determined. Exactly. Thank you.
a motion has been made by Ms. Freshman, seconded by Ms. Malice. Is there any further discussion? I will call the roll. Ms. Freshman.
Aye.
Ms. Malice.
Aye.
Ms. Clark.
Aye.
Mr. Kaplan.
Aye.
Chair reluctantly votes aye. We will defer for 2 months.
Thank you.
Thank you.
And just just to be clear, is there any chance it could be to December, or would it need to be January?
I'll defer to Blake on this one.
What's the
Sorry, what was the question?
Could they get in December?
Very unlikely,
We've
no.
already made a motion and adopted it.
Oh,
2 months deferral.
And I would suggest looking at the use permit and tweaking the plans accordingly.
Well, we're going to hit the use permit next.
Oh, thank you.
I believe I will
Good
read
cue.
the use permit. Okay.
Yeah.
So the next case is the associated use permit for this project. It is case number V-11790-22-UP-1, a use permit request by Ian Whittington on behalf of Gloria Whittington, the owner, to permit a rear setback of 12.2 feet to the wall, 11.2 feet to the eave instead of 25 feet to the wall, 21 feet to the eave as required, and to permit a left side setback of 8.3 feet to the wall and to the porch instead of 11 feet as required, regarding a new rear addition, front addition, and front porch on an existing semi-detached dwelling in the R27 zoning district on the premises known as 832 South Irving Street in the Arlington Heights Civic Association. Staff recommends that the board adopt the attached proposed resolution denying the use permit request. 2 alternative resolutions with conditions have also been provided should the BZA see fit to approve the application as advertised or with a minimum rear setback of 13 feet. There's the same supplemental materials for this case as well as were submitted for the variance.
Does somebody want to make a motion to do this all in January?
If the applicant can speak to it if they wish.
Sure.
well, I mean, obviously, I would hope that you get it today, but I will just say that we are, again, prepared to accept the suggested alternatives for the use permit.
Mr. Bone, would the plans need to be adjusted?
It would certainly, I think, make things easier to have the correct plans attached if the setback's going to be adjusted to be 13 feet. And then
Whatever you agree
the
to.
condition language could be, accurate that the plans would be built as proposed.
So there'd be a little chore there to get the plans redone so that they reflect, your agreement
Sure, that's fine.
and the backyard neighbors.
Yes.
I'm prepared to make a motion.
Okay.
In case V-11790-22-UP-1, I move that the Board of Zoning Appeals defer this matter to our January 2023 hearing.
Second.
Motion has been made by Ms. Malice, seconded by Ms. Freshman. Is there any further discussion? I will call the roll. Ms. Freshman,
Aye.
Ms. Malice,
Aye.
Ms. Clark,
Aye.
Mr. Kaplan.
Aye.
Chair votes aye. We will see you in January.
Thank you. I have 8 if you need a date, but I think you want. Sure.
When you are ready, Mr. Owen.
Okay, thank you. I was just getting my place again. The next case on our agenda is case number V-11791-22-UP-1. This is a use permit request by Richard Dooley and Lisa Larimar, the owners, to permit a street setback of 17.5 feet to the porch, 16.5 feet to the porch eave, instead of 21 feet to the porch, 19.5 feet to the porch eave, as required from the North Granada Street right-of-way, regarding a new front porch to an existing one-family dwelling in the R6 zoning district on the premises known as 365 North Granada Street in the Arlington Forest Civic Association. Staff recommends that the board adopt the attached proposed resolution granting the use permit request with conditions. I'll also note that supplemental material has been submitted for this case.
Can you describe the supplemental material, please?
Yes, the supplemental material is an online comment that was submitted in opposition to the proposal.
All right, does anybody have any questions for staff?
So there is supplemental material for this.
Yes, I believe we received
The
one
letter of
online comment
opposition.
form yesterday evening.
On the back side is a,
No, that's Staples.
that's,
It's an online
it's a
form, but
two-pager.
it doesn't have an address.
It's a
Do you know what the
two-pager. I'm
address
missing
is
a
for that
page.
person?
That was my question.
North Granada Street.
Yes, the address, I believe, for that online opposition form was 426 North Granada Street. I did want to note that we did do the standard analysis we would do for kind of neighbor feedback, and that property is located 780 feet away from the subject property.
Did you say 426?
426.
So it's not even in the same block.
Yep, it's 780 feet away, or approximately 780 feet away.
Wait, it's not in the same block?
Madam Chair,
Yes.
before we get started, I need to make a statement.
Okay.
In this case, I wish to disclose that I am acquainted with the applicant, Mr. Richard Dooley, but I believe I can rule on this case impartially.
Okay. Anybody else? Okay. Mr. Dooley? Are you Mr. Dooley?
I am Mr. Dooley.
Awesome. Would you like to speak?
Madam Chairman, and to all BZA members, I appreciate the time and attention that you're paying to this particular request. We've lived in this house in Arlington Forest for, it'll be 16 years next month. We thoroughly enjoyed the neighborhood, being with our neighbors, and we believe that this is a project, long time in coming, that will enable us to further create community and be closer to our neighbors and to the many people who are passing by, walking their dogs, strollers going by, and so forth. I have this vision of the porch happening, me sitting out there and being able to be able to chat with my neighbors more readily. So again, I appreciate the opportunity to answer any questions you have, and thank you again for your time and attention.
That was the fastest we've ever had.
Madam Chair,
Yes.
I'm sorry to be evidently disorganized, but what is do we have the address for this?
We do. It was 7.
For the neighborhood online comment form,
Yeah.
it was 426 North Granada Street. And because we usually provide you with distances to other properties for comparables, we did note that this was a property that was 780 feet away from the subject property.
So
It was a different block.
426 is a different block.
Yes.
Yeah.
Okay, next
Can,
block.
can I ask if one of the letters of support, it's not clear whether the address is 369 or 366. It's,
I assumed it was 366. but-
well, both of them were missing, but one is across the street and one is next door.
I will do a little bit of research on that, but perhaps Mr. Dooley can also clarify.
So sorry for the legibility of this. Many of these were handwritten. David Harris, I believe, is the one you're thinking of.
Yes,
You're referring to, that is across the street, that is 366.
okay.
And are we missing the neighbor to the right?
Yes.
We're not missing the neighbor to the right?
69 is missing.
No, I was able to get information from all of the neighbors, the 3 behind, 1 on each side, and the 3 across the street from us. So 369 is included in the packet.
Oh yeah, that's Marilyn Whitney. That's the first one.
Oh,
Oh, it is.
I
Yeah.
missed it. I missed that too.
I missed it
Yeah.
also.
So I had
Okay.
all the neighbors had signed on this one.
The first one I have from the neighbors is 362.
No, see that email?
Oh, it's in the email. Okay.
Yep.
Okay.
All the,
Ms. Witt.
and that's why I thought this was on the consent agenda.
Okay.
Now I wish it was.
That makes a lot of sense now.
Although we did get supplemental though.
We did, so it would have been pulled anyway, but
Right.
Anybody have any questions or comments? Anyone want to make a motion?
I will make a motion. I move that the Board of Zoning Appeals approve the attached proposed resolution granting the use permit V-11791-22-UP-1, subject to the conditions listed.
I'll second it.
A motion has been made by Mr. Kaplan, seconded by Ms. Clark. Is there any further discussion? I will call the roll. Ms. Freshman.
Aye.
Ms. Malice.
aye.
Ms. Clark.
Aye.
Mr. Kaplan.
Aye.
Chair votes aye. Motion to grant the application. I'm so sorry. The motion to grant the application passes 5-0. Enjoy your porch and your neighbors.
She was toying with you.
Do it on purpose.
Thank you very much for your time.
You're
Thank
welcome.
you.
Thank you. That concludes this matter. Mr. Bowen, can you call the next case?
I will be switching places now with Ms. Ryan, and she will be coming over here to call the next case.
Is that our last case?
Last case.
Ms. Ryan, read really fast. We can make it in under an hour. I'm kidding.
Okay, next case is case number V-11792-22-UP-1, a use permit request by David Pinkham and Nicole DeBendetto, the owners, to permit a street setback of 20.3 feet to the rear addition, 19.8 feet to the eave instead of 25 feet to the rear addition, 21 feet to the eave as required to permit a street setback of 16.8 feet to the side deck instead of 21 feet as required, and to permit a street setback of 18.3 feet to the window well instead of 21 feet as required, all from Patrick Henry Drive, and to permit a left side setback of 5 feet to the porch, 4.5 feet to the eave instead of 8 feet to the porch, 5 feet to the eave as required, and to permit an aggregate side setback of 15.2 feet instead of 18 feet as required regarding new rear side addition to an existing one-family dwelling on a corner lot in the R6 zoning district on the premises known as 5801 11th Street North in Westover Village. Staff recommends that the board adopt the attached proposed resolution granting the use permit request with conditions. And please note there's supplemental material. There is.
Oh, thank you. All right. Anybody have any questions? Anyone have any comments? Is the applicant here?
Yes, can you hear me?
Yes.
This is David Pinkham, the applicant. Yes.
Fabulous. Would you like to speak?
Sure. I'll keep this brief. So as mentioned, I'm the homeowner of 5801 11th Street North. Thank you for your time and consideration of our request for a use permit to create additional space for our growing family. One thing I'll call out that the zoning office flagged for us about a week ago was that we had not secured approval from our neighbor across the street, 5800, as well as the church across from Patrick Henry. We've since gotten approval signatures from both parties. There's an elderly woman across the street. We talked to her son-in-law who discussed the proposal with her and signed off. And then also we got a board of trustees from the church across the street as well to sign our outreach letter as well. So I just wanted to call that out. And again, thank you for your time. Happy to answer any questions.
Does anybody have any questions for the applicant?
Motion.
Yes, please.
I move Board of Zoning Appeals approve the attached proposed resolution granting use permit V-11792-22-UP-1, subject to the conditions listed.
I'll second it.
The motion has been made by Ms. Freshman, seconded by Ms. Clark. Is there any further discussion? I will call the roll. Ms. Freshman.
Aye.
Ms. Malice.
Aye.
Ms. Clark.
Aye.
Mr. Kaplan.
Aye.
Chair votes aye. The motion to grant your application passes 5-0.
Great. Thank you.
Yeah, thank you.
Madam Chair,
Yes.
I move approval of the minutes of the October 12, 2022 BZA meeting.
Second.
Motion has been made by Ms. Freshman, seconded by Mr. Kaplan. I will call the roll. Ms. Freshman.
Aye.
Ms. Malice.
Aye.
Ms. Clark.
Aye.
Mr. Kaplan.
Aye.
Chair votes aye. Motion to approve the minutes from the October 12th, 2022 BZA hearing have passed.
I would say so too. I'm still shuffling papers over here.
I'm confused.
I'm confused, you know?
No. I did tell my daughter that I might be home by 8:30 before bedtime, so she will be very excited. Yeah, I think anyone else have any other business?